I would hope that for any of us who've spent time on any of our college campuses that we would agree that was formative to the university experience was being exposed to competing ideas, challenging ideas, even repugnant ideas to our own, and that universities should not be safe spaces when it comes to students' freedom of speech, association, and academic freedom. We all know that the world beyond higher education is anything but a safe space, to put it mildly. It is a competing marketplace of ideas, rather, and I think that our universities should be a reflection of this, and anything else is a disservice to the students. The fidelity with which higher education specifically has upheld the First Amendment, I think, has been eroding in recent years. We've seen examples from around the country of content discrimination and deplatforming of particular student groups. And there have been a number of court cases on this. They've all come out on the student group side and on First Amendment grounds, insofar as I can tell. But we've continued to see universities in some cases go after certain student groups for their views. I fear in the coming years we're going to continue to see this around the country, and perhaps even here in Missouri, which is why I brought forth for your consideration today House Bill 927 to hopefully codify in state statute that a university shall not deny a student group the benefits and privileges afforded to student groups based merely upon their expressing themselves. Now, finally, this legislation, and if you read it, you'll notice there in the last paragraph, it provides that for any student organization that has been aggrieved as a result of this section can assert as a claim or defense against the institution, they can obtain relief, including damages. And so, with that, I'd be happy to entertain any questions.
Further questions? Representative Meredith, please proceed.
Good morning.
Good morning, gentlemen.
I guess it's afternoon now, just barely. I want to dig in a little bit, a couple of things you said. First of all, you talked about how we should be open to student groups having affiliation based on a viewpoint, however abhorrent it might be to us.
Well, we should certainly be open to folks having the freedom to express views that are even different or abhorrent in our own thinking. Sure.
Now, I certainly agree with expression, and I think that that's well protected, and I think you're right about that. You mentioned that the Supreme Court has really only decided cases in favor of student groups in this context.
I think, at least recently, that I'm not sure specifically about the Supreme Court, but the court decisions that have come out and just recently.
So which court decisions are you talking about?
So most recently, and this was I think in the last few weeks, University of Iowa, there was a decision.
What level?
It's the federal level. What court?
Not Supreme Court?
No, sir.
Okay. Are you familiar with any Supreme Court cases on the topic?
Not maybe specifically relating to this particular situation or context, but freedom of expression. I mean, I think there's many as it relates to that.
Again, I think we all agree here with freedom of expression, that expression is important, but acts, we may have differences of opinion on whether or not that discriminatory acts are actually allowed under the law. Are you familiar with the case Christian Legal Society versus Martinez?
I don't believe I am, gentlemen.
Okay, so I think this is a case that's actually right on point. And it was the Supreme Court talking about a public university. This time it was California's Hastings College of Law, and whether or not they could provide official recognition and benefits to student clubs that violated their school's non-discrimination policy. I think that's exactly what we're talking about here, right? A university that has a non-discrimination policy, and whether or not they have to officially recognize and give benefits to a student organization that violates that policy.
So obviously, not having read the case specifically or too familiar with it, I wouldn't want to say for certain, but I think we're talking at least in the same realm.
Yeah. So what I just described is what you're trying to say, that yes, right? Your view and your bill would say that a university does have to give benefits and official recognition to a religious group that may have a policy that violates the non-discrimination policy of the university.
Yes, I think that's right.
Okay.
Potentially in some respects, but I think what's important to note in this discussion is that many of the student organizations that you find on any given college campus, including those here in Missouri, discriminate based upon the grounds of protected classes, and so I think that's actually fairly common.
Can you explain that?
Yeah, absolutely. So I just read this case. It was University of Iowa Business Leaders in Christ. This is the one just a few weeks ago. And they noted the double standard by the university because they required in every student organization to have codified in the constitution of the student organization the university's human rights, non-discrimination, the verbiage. It included things like sex, race, gender, what you might expect or it's common to see. And they noted that, my favorite example was Hawkapellas, which I think is derived from the University of Iowa's mascot, the Hawkeyes. But it was an all-female a cappella group with membership controlled also by vocal auditions. And so you have groups, certainly, that discriminates based upon sex. And then there's many other examples as well. Another one they listed was Chinese Students and Scholars Association, which limits membership to enrolled Chinese students and scholars. In fact, I think even at the University of Missouri, there is a group by the very same name. I'm not familiar
So
with that.
is it your position then that a white nationalist group could come in and have an organization that says we only allow white members of our club, and that the school should have to provide them official recognition?
So, gentlemen, I'm not aware, and I've tried to do considerable research and looked at all of them, specifically at the University of Missouri and Missouri State, which are obviously probably two largest as it relates to student organizations. And I'm not aware of any given organization that would fall into those
Well,
parameters.
that might be because they wouldn't be allowed to right now, right? That wouldn't be allowed by the school policy at the moment. But what you're suggesting is that a school shouldn't be able to have a policy that says that, right? I mean, we've seen in other states, certainly, organizations of white nationalist students very recently holding rallies and protests. Do you think that they should be allowed to have official recognition and resources of the school?
So I think, disagree with you to some extent that this is perhaps the problem that you see it. I don't know that official recognition would provide someone the reason to come forward, and so I think that if folks were looking to organize in that fashion, they'd already be doing so even without official sanction of the school. And I'm not familiar of any of our campuses here in Missouri that
Do you think they should be allowed to, if they did?
Issues. Well, I mean, I'm trying to look at the world as it is, not as it might be in the future.
Well, I think as lawmakers, it's pretty important that we plan for the future. And if we see nationally in other states very visible, active, organized white nationalist groups right now that are rallying in the streets or wherever else it might be, is there any reason to think that within 5 years there might not be a small group even at one of our colleges that decides to do that?
There's a mass of, I just don't see this on our college campuses, but I would maybe submit to you the same question. I mean, should student groups be able to discriminate on the basis of sex or any of these other characteristics that we might, traditionally consider in this framework?
I think probably there are some narrow exceptions as to whether they can. Just like, in general, a business can have promotions for ladies' night at a bar. There are narrow exceptions where it's allowed by private actors, and then even slightly narrower exceptions in public actors, and when there's a difference. Like the a cappella group you mentioned, of course, there's a vocal question. And so it's actually having the voice that matches there. I wouldn't be surprised if some of them would actually allow a male singer in that fit in the vocal categories they needed. But I think what we're really talking about here is not just whether or not those organizations can exist. A club can exist at a school, already that has discriminatory views and discriminatory policies. They just can't have official recognition, because with official recognition comes resources, dollars, public taxpayer dollars. And the university's dollars would then be used by an organization to discriminate in violation of the university's very policies, which puts the university in a position where it's hard to say that they actually have that policy. And now I go back to that Supreme Court case I mentioned, because that's precisely the distinction they had. They held against the student groups that wanted official recognition in this case. They said, no, they're not entitled to it because we're talking about resources. We're not talking about expression, because expression is allowed. We're talking about when we put public dollars behind that expression as acts.
Now, we were talking about viewpoint discrimination here too, which I think the
We're
court's
talking about
been very clear
actions,
on.
not viewpoints.
I'm not talking about actions, I'm talking about views. Now, I do think that actions, that it's not only enough to say, well, you can just have your own views, because I could certainly say to you that you're entitled to any view you so desire, just, don't express it. I don't want to hear it. Well, that's not really, I mean, that's not.
To be clear, that court decision made the distinction that a student organization could have official recognition and resources and have a viewpoint about, if we'll talk about LGBT issues, because that seems to be the one we're talking about the most in this context, that they can have a view about LGBT issues that is not in line with the discrimination policy. However, they can't actually exclude members from their organization for that reason. And it's the act of exclusion, not the viewpoint about it, that makes it something that cannot be tolerated with the support of the university dollars. Does that distinction make any sense to you?
I don't think I would agree with your analysis there.
Or the Supreme Court's analysis?
Now, what decision was this again?
That's, I'll get the name one more
I'm
time.
not sure we're talking about the same thing, because
Christian Legal Society versus Martinez.
That's the same. That's the only case you've been referring to.
Yeah.
And Rosenberg, which I didn't have it noted here, but I believe that was a Supreme Court decision. And again, I think we're talking more about viewpoint discrimination here, and it said that viewpoint discrimination is an egregious form of content discrimination that arises when the government targets not the subject matter, but particular views taken by speakers on a subject. And I think that's more what we're talking about here, about folks' views and their ability to express them. And again, I think if you say, which is what I was trying to get at earlier, if you're only willing to say that, well, someone can think something, but they can't allow that to inform really their organization, or the freedom they're able to do in conducting themselves. And I don't really think that, I mean, the First Amendment, I think, allows for us to be able to associate in a way that we desire, freedom of association, and that you shouldn't be forced to associate with folks, that these groups shouldn't be forced to basically conduct themselves in a way that they're not intending to, which is why I would be fine with the groups we've mentioned as well. I don't see any problem with that. I think.
And if it opens the door to a white nationalist group taking benefits from a
Well,
college,
I don't see this happening, but I'm.
are you okay if it does? Because it would be allowed under your bill.
Well, I don't know where you stand, gentlemen. I usually ascribe to Jefferson's line of, if it doesn't harm me or take my money, then I'm generally.
Doesn't it take our money if it's public university dollars going toward the club? That's the whole point of official recognition.
You bet, absolutely. But I think, again, we're talking about two different things here, because the universities have created a forum for public speech. And so what we're talking about here is if we're going to allow them to discriminate or not, the universities. Because they've created this forum, which is a public forum.
But it's not discrimination if they have a blanket policy that affects all groups that accept their dollars and says that those groups shall not discriminate.
In
right?
any case in which a group has been discriminated against, in the same way they're allowing for other groups to go on and continuing in that discrimination.
I'm sorry? Say that again?
So these universities, every university that I'm aware of, has groups, has student organizations that conduct themselves contrary to the very thing that you're putting forth.
You're talking about women's groups or men's groups?
I'm talking about all kinds.
What else?
So there'll be cultural, ideological, nationality.
And you're certain that those are in violation of their non-discrimination policies? Or are there non-discrimination policies narrowly drawn to allow certain exemptions?
No, I don't believe that's the case.
Do you think that it might make more sense for a university to be able to draw those rather than us writing a blanket policy that they can't have one that impacts their
Well, again,
groups?
specifically what we're talking about, and let's be very clear here. What this bill, this bill's only 2 pages, and what it includes and doesn't include. And again,
Right, not a lot of nuance for individual narrowly tailored situations, is there?
Well, I think you're speaking of something that's not occurring. Certainly, we can't sit here and predict the future.
Because it's not allowed right now.
Say again?
It's not occurring because it's not allowed right now.
No, I don't agree with that.
If you think it is allowed, then why would we need this bill?
It's your example. It's your example that I don't agree with.
If you think that the student groups already exist that are violating the university's discriminatory policy or non-discrimination policies, then why would we need this bill?
Because we've seen across the country repeated examples of universities picking out certain groups.
You're saying based on what's happening across the country, we're dealing with hypothetical future situations that aren't existing right now.
No, they are
In our
absolutely existing right now.
What group is being denied in our state the ability to organize?
Not necessarily in our state, but certainly across the
Right,
country.
just as I said, certainly across the country, there is organization around white nationalism, right?
There's registered student organizations dedicated to this, and
I don't think they're allowed.
I would push
Gentlemen, I
on.
don't think they're allowed at any of our universities.
So you think if they were, they would be at every state university, there would be.
I'd be surprised if a few didn't pop up, yeah.
Well, and I think we need to go to and look at what it takes to start a student organization, because in many cases you have to have faculty sponsorship. There's an extensive process, and so I'm not sure they would rise to the level to be able to see their way through that process.
Okay. Last question, if you think this is a First Amendment violation, wouldn't that already be addressed by the courts?
Well, it is being addressed by the courts, so it seems to me, but it doesn't seem to be stopping universities.
Well, but the Supreme Court case that I've got says that the Supreme Court has said actually this is okay. So the Supreme Court doesn't think this is a First Amendment violation,
I'm sorry,
right?
what are we talking about that's okay?
For a university to have a non-discrimination policy and deny benefits to groups, to student organizations that violate them.
Okay, well, we just have a recent federal case that I would say looks at that a little differently. And I think the situation that's interesting here is we do have public universities that are allowing for certain student organizations to violate their own non-discrimination policy, and they're picking winners and losers, if you will. They're saying, well, and they actually, it was interesting in that case, they specifically said, yeah, we actually recognize that these groups you've noted here do violate our policy, but we're okay with that because we think it advances our educational mission. And so that's viewpoint discrimination. They're saying, well, this one's okay, but this one's not. And I just don't think that's appropriate.
Fair enough. Hey, what's the name of that case?
It is State of Iowa versus Business Leaders in Christ.
Thank you. Thanks, Chairman.
You gentlemen.
Further questions? Representative Fitzwater, please proceed.
Fitzwater, thank you. Representative, so I went to so this doesn't impact where I went to college. I went to college in a liberal arts college in South Carolina, but I worked for a ministry after college that I was participating in college, and when I was a resident advisor, and this was happening not only in private institutions but in public institutions, where we were beginning to be targeted because of our affiliations, our viewpoints. It's kind of fascinating how we say that some viewpoints, even though controversial, are okay, while others are not. And this is what I experienced even in early 2000 and into 2004 when I graduated. But working for that ministry, it was a tough road to hoe. There were just changes to policy across the public institution and private institutions on being an organization that had these religious viewpoints, it was very concerning, even in South Carolina, to move to Missouri. Can you give me a situation, just kind of give a situation, we have some hypotheticals, but can you maybe expound a little bit on the situation you're referring to that would be the impetus for this bill? I can just talk from my own experience, which saw this firsthand, was our organization had to play by a different set of rules.
Absolutely. So you asked about the one that I had referred to and the decision, and again, the decision just came down on that. That was Business Leaders in Christ. It was a student organization formed at the University of Iowa for folks in the business department who were of Christian faith and wanted to help that inform when they ultimately, kind of went into the business world and the careers that they were pursuing. So that was their perspective. They had specifically for their leadership, you had to, not to be in the organization itself, but specifically to be in the leadership of the organization, you had to affirm or sign a statement of faith that specifically outlined their view on human sexuality, which was generally what I would consider an orthodox view, an orthodox Christian view of what you would recognize as. And then the University of Iowa, upon a complaint, deregistered that student organization. That's how this found its way into the courts, and then was ultimately decided in their favor. And again, in that case, it noted that many other organizations were discriminating, if you will, or were holding that you had to act in a certain way or affirm a certain way. And it was interesting there at that university, there was actually another religious student organization that held that its leadership had also an affirmative statement of faith on human sexuality, which was the exact inverse. It was the totally opposite view, and that group went on perpetuating itself, and the university took no issue with it. And so, again, I think we've seen certainly, perhaps isolated, but certainly examples of universities picking at least on certain groups, certain organizations. And this bill would provide for any religious, political, or ideological. And yeah, that is very general, and I think that's good because I think that it's just not necessarily religious. It could be of a political group and their views, and whether it's their left and right, I don't think that we should be infringing upon their views, their ability to express their views.
And I honestly didn't come to the committee having studied the bill, so this is really kind of the first time I've perused it. But I just know from my own experience, having worked in a Christian ministry, what experiences we had serving on a campus and what other campuses were experiencing from the University of South Carolina and Clemson and some others while I was in college years, and it feels a lot longer than, can't believe it's been so long. But anyway, thanks for allowing me to give you some questions. Thanks.
Thank you, gentlemen.
Further questions? Representative McCreary, please proceed.
So I was glad in this last inquiry that it's pretty obvious that this is focused on LGBTQ people that go to public universities. That's kind of what I heard you say.
It's not for me.
Well, the case you cited
That case
talked
certainly.
about somebody having to sign their views of sexuality.
That's true.
So a Business Leaders in Christ group, in order to be in that group, you had to be anti-LGBTQ. That's what it sounds like.
You had to affirm
You
a
had to sign
statement
something
about.
that said you didn't support LGBTQ students, or people, not just students.
No.
So you described it as signing an orthodox view of sexuality.
Yeah, so, and I don't know that I've actually seen what had to be signed, but by that and what I believe I read, and again, I don't know that I've ever seen the exact verbiage, but was something to the effect of that they understood marriage to be between a man and a woman. But I think that's as far as it.
Well, and marriage between a man and a woman, and only sex between a man and a woman.
Correct.
Okay.
Within marriage, yeah, I think that's.
So I think what we're getting at here too is there's a difference between what you can do with private money and what you can do with public money. So this whole idea of like picking on certain groups, the only way that in this country that we've been able to make advances so that certain groups didn't feel like they were being picked on is we now have non-discrimination policies that protect everybody. So it sounds to me like what this bill is getting at, and I'd like you to be able to say that you're not trying to do this, is that you're okay with picking on certain groups with public taxpayer money. Because that's what this bill is about. It's about funding. So bills like this popped up all around the country after that court case in California. And it was a group that it was within a law school at a public university. The school allowed them to meet on the school property. They were allowed to put flyers up. They were allowed to do everything except for taxpayer money was not used to fund the organization because it went against the non-discrimination policy of the university, which is a public university. And so I think, I just want to hear why you're okay with that, why you're okay with, and I'm using your words, picking on certain groups. Because to me, this feels like we're picking on a certain group.
I'm not sure I understand the question. You're saying that I desire to single out certain organizations?
The origins
and
of these
discriminate
bills
against
from
them?
around the country. This bill is not unique to Missouri. This is not unique. There's a national movement to get things like this passed as a result of that U.S. Supreme Court decision that said it's not okay to pick on LGBTQ people. It's not okay to single them out. It's not okay to pick on them.
Okay, so yeah, no, I would not acquiesce to that. I mean, that's certainly not my.
But that's what your bill does.
I can't speak.
That's
to
what your bill
anybody else.
does.
No.
It says
lady,
that-
it protects any religious, ideological, or political student group.
This
That's
group was
what it
allowed, this U.S. Supreme Court decision allowed this group to discriminate against LGBTQ people within their organization at a public university. The only thing they couldn't have was taxpayer money, because as taxpayers, we have some basic things that we hold true. And although this was a case in California, it was affirmed by the U.S. Supreme Court, and I think it's safe to say that in Missouri, we don't think it's okay to pick on LGBTQ people. So what you're saying with this bill on line 5, that we're okay with using funding sources, I would argue that there are not taxpayers in the state of Missouri that are okay with us picking on certain groups, including LGBTQ people. So what are you trying to get at with this bill?
I'm trying to provide that no student group that's religious and holding to their religious views, their political views, their ideological views is singled out for that in an what I view as an inappropriate way. And I think
Well,
we've
is
seen
it
that
happening in
across the country.
Missouri? Is any of this happening, or is this all hypothetical?
So I think we've seen some things in Missouri that are somewhat troubling. There's no specific examples like of the cases we've talked
So
to.
this is a bill, a solution looking for a problem, based on a national movement.
No, I think it's certainly warranted due to the climate, the atmosphere we've seen. I mean, I would just be interested.
Well, I'm concerned, like Representative Meredith, I'm concerned about the climate that we're seeing at other campuses with, in the last couple of years, hate crimes have gone through the roof, including against Jewish people, and this white national movement is active, not just like in adults, it's active on campuses as well. So the way this bill is written is it would be opening up a Pandora's box. And I wish that you would be more specific about what you're trying to get at here, something besides hypothetical or things that we're concerned about.
I mean, I'm sorry, I haven't
Question.
been
Is there a question?
clear enough.
Yeah, I'm trying to get him to say what he's trying to do with this bill.
And I've already expressed that, I feel like, multiple times. It's to protect any student organization that's political, ideological, or religious, to be able to conduct themselves
Okay,
according
and
to
that's
their
already
sincerely held
allowed to be
beliefs.
done now at Missouri campuses, at public campuses. So the part of your bill, though, is the funding. So you're okay with public taxpayer money being used for organizations that discriminate? Because that's what this bill says.
Is there a question?
Yeah, I'm asking him if he's okay with public taxpayer money being used to support a group that discriminates.
That's the question.
Yes or no?
Student organizations are allowed to receive all kinds of benefits, right? Facility access,
Right.
to be able to hold meetings. And so what this bill says, and what that provision is specifically relating to, is saying you cannot pick out certain student groups and hold them to a different standard versus all the other student groups.
And is that
based
happening now in the
upon
state of Missouri?
this criteria? Not that I'm aware of, but I
Okay.
certainly
Very
think
good.
it's
Thank
within
you.
the realm of possibility.
Further questions? Representative Rogers.
Good afternoon, how are you?
Dude, Joe, I'm good, thank you.
Just one question. You had said we've seen some things in Missouri that are somewhat troubling. What have you seen?
Yeah, so at Truman State, there was an instance of a student group, YAF, and having a speaker come in, and there began to be protests about this speaker. And so, again, it's my understanding that another student group, and kind of in conjunction with the university, brought in kind of a competing speaker and had it in the same room right beforehand. And it wasn't to the point of, as we've seen in other states, of canceling the event entirety, but it certainly seemed like they were kind of acquiescing in a way that's potentially, getting very close to that point. And so again, I think just for the climate we're seeing around the country, and that's one example. There was another at UCM, very similar situation, bringing in one speaker, and then there began to be some controversy, and that speaker was not canceled. These were both political in nature. And they had another group come in that again was the opposite, which I think is actually very healthy. But what does concern me is there's certainly clamoring for, we've got to deplatform these people, we've got to shut them down. And I'm just trying to make sure people can continue to express themselves. And what's so amazing is you think freedom of speech hasn't always been welcome on college campuses, right? And this could cut either way, okay? I mean, and I think that's why this should be a bipartisan issue, because we saw UC Berkeley, with protests over the Vietnam War and things, academic freedom, there was a big push there as related to freedom of speech. And so we did good for many years, but now I fear it looks to me like we're kind of going back the other way. And that's what I'm trying to counter against.
So the group at Truman, you said it was White AF?
No, YAF. It's Young Americans for Freedom, maybe. I think might be
Well, who are they wanting to bring in?
the gentleman name was Robert Spencer.
Okay, and then how about at Warrensburg?
It was